chat ruling. This is my little chat ruling. Because the prosecution does not oppose bond being granted to the accused, but have filed an affidavit proposing strict terms for such bond, the task of the court is reduced to consider as to whether the prosecution's proposals are reasonable to meet the ends and objects of grant of bond in the administration of criminal justice. Ipso facto, therefore, there is no compelling reason to deny bail to the accused person. He is granted bond. The remainder of the endeavor due in this determination must therefore take cognizance of the law that bond is a constitutional right and an important aspect of the non-derogable right to fair hearing. In a criminal trial, the right to a fair hearing is not only vested in the accused alone, but to all concerned. The victim, the prosecution, and the society it represents must be given the benefit of that right. The Supreme Court settled that position when it held in Francis Muratetu versus Republic, and I quote, "Indeed, the right to fair hearing is not just a fundamental right. It is one of the inalienable rights enshrined in Article 10 of the Universal Declaration of Human Rights, and in the same vein, Article 25C of the Constitution of Kenya elevates it to a non-derogable right which cannot be limited or taken away from a litigant. The right to a fair trial is one of the cornerstones of a just and democratic society, without which the rule of law and public faith in the justice system would inevitably collapse." It went on, "A fair hearing as enshrined in Article 51 of the Constitution must be read to mean hearing of both sides." End of quote. I have duly taken cognizance of the averments in the affidavit sworn by number 237692, Inspector Peter Kamau, as well as submissions offered by counsel from both sides. What comes out from both is that being the member of parliament elect and having served in the previous term of parliament, the accused has considerable influence and sway within the constituency and indeed the larger Bungoma County, where it is alleged the offense occurred. On that common position, the question for clearance is whether it would serve the interest of justice to allow the accused back into that community of Kimilili constituency and to interact with all, including witnesses, to give him the benefit of a licensed gun holder to continue holding gun, the question of misuse of such rights being at the center of these proceedings, and whether in its stature in society he needs sureties in addition to a personal bond. The circumstances here are such that it is desirable for the protection of witnesses, their families, and friends to be protected not only by being removed from the society under the witness protection framework, but by the accused, being the person in conflict with the law, being excluded from that environment. The court also appreciates that the circumstances said to prevail and reasons for determination in the Nairobi petition number E069 of 2021 do not include the occurrence and circumstances of the 9th of August 2020 so as to be undesirable for this court to comment upon. I do find that for this matter, it is the alleged misuse of the privilege to own and hold a gun that is being questioned. For public good and security from fear of misuse of guns by those privileged to hold them, it is only necessary that pending the trial of this matter or further orders of the court that the accused is denied that privilege. For those reasons, it is directed and ordered that the accused may be released on his personal bond of Kenya shillings 10 million, with one surety in the sum of Kenya shillings 5 million. The accused shall, in addition, do the following as terms of bond to be released. 1. Deposit his passport in court not later than noon on the 25th of August 2022, to be so held until furthers of the trial court. Number B. Surrender all guns in his possession or control to the DCI or his agents whenever such guns could be situated within 48 hours from now. Number C. Not to visit any place within Bungoma County between now and the date all the civilian witnesses shall have testified, or as may be further orders by the trial court. Number D. He shall equally not contact any of the witnesses in the matter, whether directly or indirectly, in person, by telephone calls, messaging, letters, or otherwise, pending the determination of the matter. Number E. Being a politician who shapes and influences public opinion, he shall not make any comments over these proceedings, be it at funerals, radio or TV stations, pending the determination of this matter. For avoidance of doubt, these additional conditions are as substantive to the bond granted, and any violation of any of the terms shall automatically lead to bond cancellation. As parties agreed that the identities of the witnesses be protected from disclosure, the prosecution is given a period of 8 days from now to redact the witness statements as to sufficiently conceal their identities and contacts, and to supply copies of such statements, as well as copies of any documentary exhibits to be used at trial to the defense within 10 days from today. We shall now take a mentioned date for case conference. Which date? Yes. Yes.
I have one prayer.
Yes.
To ensure that we are not in conflict with the orders of this court.
Yes.
Which I have instructions from the man to request that he be granted limited access to his home to leave the power of collecting personal effects and to enable him to collect the certificate for his declaration as the member of parliament elect for Kenya constituency. That visit to lordship can be limited to not more than 2 hours to ensure that we do not turn in conflict with. I doubt my friends on account of the
Why don't you take a date, then you make that application, because there's a ruling, and that put the mentioned date as part of the ruling. Yes. Then you make your application.
Thank you.
Is that okay with everybody? Yes, Mr. Torre?
Yes, my lord, having had the ruling of this honorable court, my lord, we respect the statement intended by the my lord, says that we wish to make an application for a slight accommodation in our interest of justice.
Yes.
My lord, the accused person's wishes to be granted gift by this court to access his home and community for purposes of collecting this person's effects that is required in his Nairobi room for the duration of the trial. And second, your lordship, collect the certificate of declaration as the member of
is getting it from the constituency returning officer.
Yes, we will find out where he is, probably in Goma or I'm told in Kimberley.
In Kimberley.
But if the court is so mad, it can be supervised in a likely event. My colleagues feel that may be a possible threat related to their witnesses.
It can be supervised by
It
who?
can be supervised. I mean, they think that they need to be accompanied. We have not seen that observation, but don't think it's necessary because just for a limited hour, probably now. Also. Of course, that it's necessary that you should be able to do degree to ensure that it's right to privacy and that, because that is not very.
Yes, Mr. Kipro.
Yes, the Lordship, we are supposed to have a petition. It's a fair application that collects his personal effects and certificates. Only that because he has not processed his phone, he has not been released officially, and the condition set by this court, he be accompanied by the DCI officers to collect his personal effects. The Lordship, we further to that application, prosecution will request for accepting that ruling. Certified.
It can be asserted by DCI.
By DCI officers.
You are proposing now or not?
Whichever is convenient. Tomorrow is now. We will make our own arrangements.
Yeah.
We are requesting for typed and certified copies of the
I'm just wondering, must parties ask for court rulings to be given?
At times it takes long, so they require that you apply for it, and it's processed.
Okay.
They are asked that you
So what's a type ruling?
yes. So, then in the meantime, if the accused person cannot process the bond process by the court, he will remand at the Kisumu police station.
Where?
Kisumu.
I want you to comment on this, then you can make yours. Just like Kiprot has commented and made an application. What is your, I want to finish with you. What is your prayer?
I have been asked by one of the witnesses that motor vehicle registration KCR 050J.
Motor vehicle?
KCR 050J. Be released since it has already been processed.
Be released to who?
To the owner, one of the witnesses, because of the directive of the court, I did not mention the name. Since it has already been processed, the release to him for this and so that it does not waste away at the police station.
I think I would want Mr. to begin if he has anything about what they said and what you say about Matete's request.
I'll have my colleague do this.
Your Lordship, it is difficult for us to respond Because we have not been served by the necessary evidence the prosecution intends to rely on. We don't know the extent of the participation of this motor vehicle in this alleged offense. I would be inclined to pray that they make a formal application.
This is informal.
At least written. Your written application will have, we expect to have the vehicle disclosed, and so many resources to enable us extensively respond to it.
I think you didn't help us much. How is the vehicle related? So that everybody understands.
My lord, the deceased was in the motor vehicle when he was shot. Therefore, they took ballistics and blood samples, and they have already been processed.
That's the vehicle where the deceased was.
Yes. I think the prosecution confirmed that the reports are back. And therefore, photos have already been taken. So I don't know what else.
It's okay. That to me is sufficient. Madam Masai, you want to add anything? Or what? We'll leave it together. Mr. Kiprop?
Yes, Your Lordship, we will put our application at this stage. The vehicle is question is an exhibit. And that the investigation and forensic investigation particularly that motor vehicle is still ongoing. Your Lordship, we have not received forensic reports relating to that motor vehicle. And I have not had my colleagues indicate if they have seen one of those reports. The government case report particularly is still pending. And until investigation is completed, and that motor vehicle is produced as an exhibit, my Lord, we wish that the same remains with the police for purposes of protecting the necessary forensic evidence that we need. Maybe my colleague can, at some point, within the course of time, can make a formal application so that we respond and give the progress that the police they have made regarding investigating the crime. But for now, we object to that.
Do you have the IO in court?
Yes, the officers are here. Inspector Peter Kamau is the
Who mentioned something about ballistic report in the course of these proceedings? Or I read it somewhere?
Yes, you have mentioned
Yes.
that there are preliminary reports about ballistics.
Okay.
Yes, but that is totally unrelated to
To that application. Bwana Kamau, you still need the vehicle?
Yes, we still need the vehicle.
Okay.
Actually, the vehicle is right now.
It was your application. You want to say something lastly?
Yes, yes. Remember, they have taken photos. They have taken.
You have seen the photos they have taken? I'm told by her But you need to see what Kiprop has so that you know what is it that has been taken, what is yet to be taken.
And my issue is with the application that they made at the
Yes.
I don't think that would be appropriate because my client has a right to his property. And to have it an administration addressed away. It's not his fault that whatever happened should not be denied access to his whatever. Therefore, if they can give us maybe by time and time, whatever investigation has been, or whatever.
Director, you were raising your hand.
Your Honor, we still need to give, we have a preliminary report of the ballistics, but we have got other reports like the trajectory of the movement which will need the demonstration through the vehicle itself.
Okay.
We also still have some pending analysis by the government. The same vehicles is being referred to numerous witnesses.
what I've said by overruling. The order that the accused does not visit any place within Bungoma County is tinkered with to the effect that he may, in the company of DCI personnel, visit his home and the offices of the county returning officer, Kimilili, constituency, not county, constituency returning officer, Kimilili constituency, for a span of not more than 3 hours on a date and time agreed between his counsel and counsel for the prosecution. During the visit, however, he shall not have the liberty to address any public gathering of more than 5 persons. The request by Mr. Matete for the release of the motor vehicle KCR 050J is declined just now, pending the supply of the witness statements and copies of the documentary exhibits. In that regard, liberty is granted to Mr. Matete to make a formal application as and when he is ready. I've added that if for any reason the accused is to be remanded, let him be remanded at the police station. Why particularly Kisumu?
The restriction is where he has been. 2, because of his security and convenience.
Can there be insecurity in a police station?
No, not really.
Yes.
That is where he has been, and we told him that to be a computer, but we have decided by the direction.
If he has to be held in custody tonight, let him be remanded at Kisumu Central Police Station.